that order or statute specifically identifies it as confidential criminal history record information. And you may hear about one of those exceptions later today, because DHHS, Child Protective Services, can get access to confidential criminal history record information for the purposes of abuse and neglect investigations. Because there's a statute outside of Title 16. It doesn't live in Title 16. I think it's in Title 22. There's a specific statute that allows it. Another example might be in discovery. There are court rules, or it may be pursuant to an order from a court in a particular case to the state to provide confidential criminal history record information to the defendant as part of discovery. Somebody else's criminal history record information, because the defendant would be entitled to his own confidential criminal history record information. But the court may order the state to provide somebody else's information to the defendant if it's essential, or not essential, if the defendant is entitled to it as discovery in that case. C, any person with a specific agreement with a criminal justice agency to provide services or to conduct investigations determining employment suitability. So those are two very different things. The first one, the example that comes to my mind is Maine Pretrial Services, which provides screening and supervision of persons for bail purposes. That's a specific agreement with a criminal justice agency to provide services required for the administration of criminal justice. A separate category under that paragraph is employment suitability of prospective law enforcement officers. Again, that's something you need to know the background of your law enforcement officers. And if a law enforcement agency has contracted with a private entity to conduct those evaluations, a fitness for duty evaluation, they have access to that information. D is an exception for research that has to include confidentiality provisions. E is interesting and very specific. As someone once referred to this category, it described this category to me as the exception for somebody who already knows too much, or say something's already been in the media, and the media is following up and saying, hey, this specific person, this specific person was arrested on this date, were charges brought against this person. But if you look at the language, it's very specific, and the person inquiring has to name the individual and reference a specific date in order to get the information. F can be a large exception to, so think back to that list of confidential criminal history record information. This is a 30-day window that allows for the most part, the state to explain what happened in a case that's, think of it as being something that's already known. So say there have already been reports in the media about somebody being arrested and charged, and the grand jury declines to indict, and the newspaper is following up and says, hey, what happened to, I know this matter I know this person was charged, and it was supposed to be presented to the grand jury. What happened to it? What the legislature has decided is that, well, we have to provide for this window so that within 30 days, we can actually say, you know what, that person is not being, grand jury has declined to indict. Or this can be any disposition. The jury acquitted, or the prosecutor decided not to charge because there wasn't sufficient evidence. So there's that 30-day window. But it also provides for the person to whom the information attaches can authorize that release at any time. I mean, if I'm investigated and the prosecutor ultimately decides not to charge me, I want everybody to know that. So I may authorize the prosecutor, or I may authorize the law enforcement agency to say, yeah, you can tell everybody that there was insufficient evidence to charge me. So that's an example of where the person can control his own confidential criminal history record information. And then the last one is an exception for the purpose of visas and citizenship. This section also has that required inquiry to SBI. So again, before a criminal justice agency provides any confidential criminal history for non-criminal justice purposes, they have to update it through SBI, again, to make sure that it's accurate. Any questions? I know I'm not going through absolutely every word, so stop me if you have any other question, if there are questions.
Any questions from committee members? So I have a brief question about the person themselves can authorize the release of confidential information, which I understand the example you gave. You know, people may want it known that the case was dismissed or something of that nature. Is there any provisions in other statutes about someone requiring someone to sign such an authorization? In other words, could an employer, for example, to get around this confidentiality statute, make as part of the application process, the person applying sign an authorization to release confidential information?
I'm not aware of anything like that. That doesn't mean there isn't something like that, but I would be very surprised if there is. There may be for, I don't know. I don't know if there is for military service. But
So
yeah.
you're not aware that it's prohibited, though.
I don't think we have a statute that says, you mean that would prohibit somebody from asking for a waiver?
Yes. That's a succinct way of putting my long question. Thank you.
I'm not aware of that. That doesn't mean it doesn't exist, but I'm not aware of that.
Okay.
I haven't heard of that.
All right. Thank you.
Laura, it's Matt Ruel. I was just going to also chime in, from a practical standpoint, I don't know how we could do that. Normally, well, if somebody was going to say, Laura gave permission for you to see my criminal history or to run it, most of that happens electronically. So I don't think we would really be able to do it that way. Nor do I remember a case where that's happened. So I just don't think that's really going on.
Yeah, I don't, you're right, Matt. I don't see how that would work with anybody requesting the record through you electronically.
Right.
Maybe if they went to an individual law enforcement agency with a waiver in hand, but
I think people would be skeptical of that, personally.
yeah. I can see that.
Yeah.
Okay. Thank you. Any further questions from committee members? Not seeing any.
Okay, so 706. Oh, 706 is interesting because it's, even though there's overlap with a lot of what is criminal history record information, this is designed to get at something different. So if you look at this, this applies not to all criminal justice agencies, but criminal justice agencies that maintain holding facilities. So think jail or, temporary holding facilities that a municipal police department may have before taking somebody to the county jail. And you'll see that this statute requires the holding facility to maintain a record of anyone who's been arrested and detained. So anybody over whom the facility has assumed physical control. And then this information is public. And you say, well, why? I can remember when I first came across this, it didn't make sense to me. Well, why is this information public if somebody's arrest may ultimately drop off their SBI and not be public if the person's not convicted based on that? Well, first you have to understand that this record maintained by the holding facility doesn't go to SBI. So it's not part of the unless it's separately submitted by the law enforcement agency and goes through the process. So don't think of this record as maintained by the holding facility as what's going out from SBI. But what is this designed to do? This is designed to protect against secret arrest and detentions, and to make sure that people are brought to court in a timely fashion and their other constitutional rights are guaranteed. So this is designed as a protection against overreaching by the state and secreting somebody away. Does that make sense?
Yes.
Okay. Let's see, 707. 707 is important because this tells you that the legislature takes seriously the deliberate violation of this statute. And I use the word deliberate, but the technically correct way to describe it is if a person intentionally disseminates confidential criminal history record information, knowing it to be in violation of the chapter, that's a Class E crime. So I think that's important to know. 708.
I do have a quick question, if you don't mind pausing. This is Michael Cabeta.
Yes, hi, Michael.
Nice to see you, Laura. I was curious about what you thought about the intentionality and knowledge requirement as compared with the rest of the law, where there is less of an intentionality, or there's less of a requirement that the person actually know that what they're doing is a violation of the law, and whether you have any background about the history.
What do you mean the rest? Which portions are you talking about where they're not being?
Well, for instance, if a person, vandalizes a trash can, let's say, and they didn't think they were violating the law, but they got arrested for that. There are sections in
so you're talking about the criminal law in general, why the
Exactly.
legislature chose this culpable mental state for this particular crime.
Yep. Yeah.
I don't know for sure. I mean, as I read it, it's clear that the legislature did not want to criminalize negligent or reckless. The person meant to do wrong. The person meant to give out. If the definition of intentionally is that it's the person's conscious object to achieve the result. So to violate this, I would basically have to have done it on purpose. I want to give out somebody's confidential criminal history. I know I'm not supposed to do it, and I'm going to do it anyway. So, and it doesn't have to be for any nefarious reason. Maybe I've got a I have a neighbor whose daughter is dating somebody that might seem kind of sketchy and she's worried about, and so I look them up and I say, okay, I know I'm not supposed to do this, but I'm gonna provide you with this information. That's
And
all
what
it
was,
would take, really.
yeah,
But I don't know, I don't know why it says intentionally or instead of, for example, intentionally or knowingly.
okay. And do you know if anyone's actually been found guilty under this section?
That I don't know either.
Okay, well, thank you.
Any further questions from committee members? Seeing or hearing none, you can proceed.
So 708, this tells you all the things to which the Criminal History Record Information Act does not apply. And if you, you can see there are things in the public domain that can't be brought back within the ambit of the Criminal History Record Information Act. For example, what if there's a transcript of a case that went up on appeal to the law court, and that, well, no, I don't know if that's a good example. This is really difficult to explain. Some of them are obvious, posters identifying wanted persons, police blotters or something that are frequently requested by the media, records of public judicial proceedings like docket records. What you have to understand about the court, though, is that the court has control over its records. So the court has its own retention and public access policies. And what the court has tried to do for the most part is track the Criminal History Record Information Act. So I believe what you will see in the administrative orders is that the court references the Criminal History Record Information Act and treats as confidential those things that are treated as confidential under the Criminal History Record Information Act, so that you're not getting different information in each place. And Jordan, if you're here and I've said that wrong, please jump in. Otherwise, I'll just plow ahead.
You're correct, Laura.
Okay.
The court did not want to have one set of records saying they're public and another set of records saying they're confidential.
Okay. Now, what's interesting about this provision, and this goes back to when this was adopted in the mid 70s, is this this exception for the court that allows it to govern access to its own records is there for a number of reasons. Number one, it recognizes that the court is a separate branch of government. Number two, there was something called practical obscurity back in the mid 70s. And what the legislature was doing is recognizing, well, we have the State Bureau of Identification, that's a central access point. That's going to collect all this information. It's going to be easier for people to get information there than if they have to walk into the individual courthouses to get information about an individual. So back in the 70s, before the internet, having certain things public at court didn't really mean that they were necessarily all that public unless you knew which specific court to go to and what record to request. That's less so now, and I think the court has recognized that and attempted to have its policy track this policy that the legislature has adopted. Number 4 is kind of a necessity, published opinions. I mean, what happens if there's a case that goes up to the law court and a conviction is vacated? That's all been public all the way along, and the decisions of the law court are published. They're published in books. They're used as precedent. They teach us, they teach lawyers, defense attorneys, prosecutors, police officers, the public, what we can and can't do. So those published opinions remain public. And then there are just a few other exceptions. Records of public proceedings. There are other public, obviously, we're engaged in a public proceeding now. That's being recorded. That's an example that would come within sub 5. Traffic crimes are specifically excluded, but remember, those are not maintained by SBI unless they pertain to OUI offenses. And pardons other than full and free pardons. Remember when we were looking at the list of confidential criminal history record information, it included full and free pardons. Well, this tells us that information in petitions for pardons, commutations, reprieves, and amnesties are not covered. Or the criminal history record information in those petitions is not covered. And they're posted publicly. When somebody applies for a pardon, that's actually posted publicly. There's a public notice that goes out. I think that's all I have on 708. 709, just really quickly, the important thing to know about 709 is that a person can access and review his or her own criminal history. And if the person wants to challenge it, if the person says, hey, that's not me, I wasn't arrested on this date or at that time, or I'm not convicted, the person has a right to challenge it. And SBI has a process for responding to that. They'll, very often a person doesn't come in with all the information that they need. So SBI will send them a form, which they can complete. And then SBI actually does an investigation where they try to match up dates and addresses and descriptions in law enforcement records to confirm whether or not the record is correct. And I've seen a couple of those where a record has been changed and an event has been taken off someone's record when it's been challenged. And that's all I have. I know it's a lot and it's kind of granular. If you have questions as we go along, as we're addressing any of the other issues that harken back to the Criminal History Record Information Act, I'm happy to try to pay attention and respond as best I can.
All right. Thank you very much, Laura. Any further questions for Laura at this time? I don't see or hear any. So we will just keep moving on. Our next presenter is John Feeney from the Department of Health and Human Services, talking about how they use criminal history record information in child welfare proceedings regarding abuse and neglect. And I know, Mr. Feeney, you had provided the committee with a lot of information in this regard as well. So thank you very much for that. And whenever you're ready, you can proceed.
Okay, well, thank you. As introduced, I'm John Feeney. I'm the Chief Operating Officer here at Child and Family Services. So the information that I provided previously, that pertained to substantiations of child abuse and neglect. When I saw the agenda item, I thought we were talking more in terms of criminal history records. So I went to our policy that pertains to criminal history records. And what I'd like to do is just share what's in that policy. And I think it's going to be a little bit different than what was previously provided. Okay.
Okay, thank
So
you.
in order to determine whether a child has been or is likely to be abused or neglected, and potentially what services are necessary to protect the child welfare may need to access criminal history records of persons who are or may be significant in a plan regarding the child. This information is used by caseworkers to better assess the risks involved in alternative plans for the child. Typically, caseworkers' requests for criminal history records will be made on a couple occasions. One, there is a reason to believe that there is criminal history information which is relevant to the plan to protect the child. Or two, an application with a signed release is received for a foster home, a child care licensed facility, or a plan to adopt a child. The crimes or offenses most likely to be relevant to possible harm to a child would involve violence, particularly in the family context, negligence with respect to family, sexual misconduct, abuse of drugs or alcohol so that general functioning is impaired, or serious antisocial behaviors. By policy, caseworkers are directed to consult their Assistant Attorney General regarding relevancy questions of any of these crimes. There are a couple ways that caseworkers obtain criminal record information. The person in question will be asked about criminal history information and requested to sign a release. I'm told by caseworkers that this is pretty rare. Caseworkers can get the official criminal history record information from public or confidential sources, a lot of what Laura just shared with us. They can go to local police records, they can go to the SBI public access portal, or a number of sources to go and get that public information. For confidential records, the Child Welfare Background Check Unit, who has access to federal databases, provides date and jurisdictions to a caseworker when there is an item that is of concern. The caseworker then must request criminal record information from the jurisdiction. The background check unit's not allowed to disseminate that information, as Laura pointed out. Caseworkers can request out-of-state official record information through law enforcement or by directly contacting the child welfare counterpart agency in that state. Maine law regarding access to records does not apply in other states. However, a counterpart agency, child welfare agency, may have access through its own state laws. The other state most likely will require a written request. Also, if the counterpart agency is unclear about access to records or unable to release this information, the caseworker will ask the agency to identify its legal advisor, and we'll refer the matter to our Assistant Attorney General, and we'll let the legal folks handle that coordination. When a confidential criminal history record is obtained, any information which is not relevant to possible harm of the child will be deleted prior to the information becoming part of the department's case record. Confidential criminal history record information cannot be disseminated further except in accordance with Title 16, as Laura pointed out. Out-of-state criminal history records obtained by the department are not subject to Title 16. However, as a matter of policy, child welfare will treat these records in the same manner as Maine records. And confidential records obtained by consent are not subject to Title 16 as well. However, the department will treat these in the same manner unless the client consent authorizes disclosure. That concludes my comments here. Not nearly as granular as Laura's, but hopefully I hit on some points that are helpful to this committee.
Thank you very much. Any questions for Mr. Feeney from committee members? I'm not seeing any. Thank you. Our next presenter is Ann Head, the Commissioner of Department of Professional and Financial Regulation. an Assistant Executive Director of Board of Licensure in Medicine, Judy Shaw, Administrator of the Office of Securities, and Christine Fournier, Principal Consumer Credit Examiner, Bureau of Consumer Credit Protection, discussing the use of criminal history record information in their relevant departments. And I'm not sure who is going first. I see that we do have in our package the occupational license disqualification on basis of criminal records and some other information. So I'm looking on the screen to see who's kind of, oh, I'm looking on the screen and you're in front of me. That's probably why I don't see you on the screen. Welcome. And yeah, Peggy's going to turn the microphone on for you. There you go.
Thanks
Well
very
said.
much.
Thank you.
Yes, my name is Ann Head. I'm the Commissioner for the Department of Professional and Financial Regulation. I really appreciate the opportunity to come here today to speak with you about some of the issues that we deal with in the Department of Professional and Financial Regulation. And because we have 5 agencies and 6 affiliated licensing boards that are all using criminal history conviction records in the licensing process, we thought it would be more appropriate for each representative of an agency to speak with you directly or on the screen, because we use criminal information in very different ways and from different sources. So I'm going to go ahead and give you just a little bit of information about how these agencies are structured. We have 5 of them. The Bureau of Financial Institutions supervises state chartered financial institutions, including banks, credit unions, non-depository trust companies. The Bureau of Insurance obviously regulates individuals and business entities related to insurance, insurance companies, agents, and pharmacy benefit managers. The 3rd agency is the Bureau of Consumer Credit Protection, which regulates many aspects of the consumer finance industry, including non-bank mortgage lenders, debt collectors, loan brokers, retail creditors, and on and on. There are various different licensing categories for that agency. The Office of Securities regulates broker-dealers and their agents, investment advisors, and financial planners. And then I'm also the agency head for the Office of Professional and Occupational Regulation, which regulates many, but not all professions and occupations. And then we have the 6 affiliated boards. You're going to hear from Tim Tarano later from the Board of Licensure in Medicine, osteopathic licensure, dental practice, optometry, licensure for professional engineers, and the State Board of Nursing. Those are separate but affiliated agencies. So you also have in your files a letter from Eric Chapa, who's the superintendent of the Bureau of Insurance. He was not able to participate today, but we'll answer any questions you have after this meeting. So the Office of Professional and Occupational Regulation is a combination of 37 licensing programs, all within one state umbrella agency. It is not a criminal justice agency, so we do not go beyond what our authority allows us to do. We are guided by Title V, Section 5301, et cetera, and we call that the Occupational Disqualification Statute, which is part of Title X. This is a piece of law that tells us basically 3 things. We're not to treat this as an automatic bar. A conviction should not be treated as an automatic bar to licensing or a profession. That's number 1. Number 2, even if convicted, there is always a way for an applicant for licensure to make the case that he or she has been rehabilitated after that conviction. That is called an adjudicatory hearing. That is the right of any applicant if they fall into one of these categories of convictions. So that's a second guide. And then the third guide is what we can look at and consider as licensing agencies when we ask for criminal history information. I want to say from the get-go, when we ask for an SBI record and we receive that, the typical report is either nothing on this person's record or yes, there is something. And then we have to take it from there and look at section 5302, subsection 1, that tells us how that conviction can be treated by a licensing board. So I want to say very strongly that this statute is not used by these licensing boards as a bar to licensure in a profession. In fact, there are very, very few instances where the fact of a conviction disqualifies an applicant. In fact, we have taken off all of our applications any reference to criminal history records. We just don't ask that question because we didn't want applicants to take the reference to a criminal conviction as an obstacle that they could not overcome. So by removing that section that we used to have for many years, we have tried to avoid any impression that there's no way they can get licensed. So with that said, I do want to go through some of the specifics here under Title V, the Section 5301, which states that a licensing agency may take into consideration criminal history information from Maine or elsewhere that has not been set aside, and et cetera. But the existence of such information shall not operate as an automatic bar to being licensed or permitted to practice. So that really gives us the sense of what the legislature in this piece of law wanted us to do. Section 5302, subsection 1, indicates that if, for example, there is a conviction that falls within this section, they have an opportunity to show to a licensing board that they have been substantially rehabilitated to warrant the public trust. So there is always an opportunity for an applicant for licensure to make that case. Going to subsection 2, we see a lineup of exactly which cases could be considered by a licensing board. And these are all important. Convictions for which incarceration for less than a year may be imposed, or which involve dishonesty or false statement. Convictions, B, convictions for which incarceration for less than 1 year may be imposed and which directly relate to the trade or occupation for which the license is sought. Convictions for which no incarceration may be imposed and which directly relate to the trade or occupation for which the license is sought. D, convictions for which incarceration for 1 year or more may be imposed. And for healthcare licensees, convictions for which incarceration for less than 1 year may be imposed that involve sexual misconduct. So the legislature thought it was important for health-related professions and their licensees should have a higher standard for their the conduct that they may have engaged in that involves sexual misconduct. And that there's a long list of licensing programs that fall into that category. Then the last section sort of rounds up the topic here and says, gives us how far back a licensing board can go in considering a conviction. For most professions, I'm not including the healthcare professions for which there's a sexual misconduct charge. There's a 3-year look back. So if we see an SBI record report whereby the conviction, the one conviction this individual may have is 5 years prior to the time of submission of an application, we don't consider that. It has to be within the 3-year look back. So anything beyond 3 years for many professions is not part of our consideration. However, for those boards that do, where there's an example of a conviction that does involve sexual misconduct, that is a 10-year look back. And that was a decision made by the legislature that those were significant enough to be considered by a licensing board, even though they may be 10 years old. So that's in essence how we treat criminal conviction records. As far as I know, when we ask, the rule in this agency is if you are an initial applicant for licensure, you will be asked to pay for an SBI report on your conduct. It's a minimal charge. Everybody understands that's going to happen. And when that record comes back, and many of them come back clean, but if they don't come back clean, that is a record. It's a business record of the agency that goes into someone's licensing history. We keep that, but we are always concerned when someone other than the applicant requests that record. At that point in time, all we see is one SBI report. So if someone does request that under a freedom of access statute, that becomes a legal decision by our staff attorney in combination with the assigned assistant attorney general for that program. And there are many reasons why it might be considered confidential. Not that we had anything to do with that, but we are concerned that someone who knows something about an applicant may say, under freedom of access, I would like to see this person's license history. That's sort of a problem. I wouldn't want to do anything with that until we consult with our legal counsel. So, as far as we're concerned, we're doing exactly what the occupational disqualification statute tells us to do. And as I said, we have very, very few applicants with a conviction that is not given an opportunity to explain that. And there have been many instances where that's happened. And as I say, very few applicants who have been turned away. Actually, we license people in incarceration right now in our jails. If they have an interest in one of these professions, there is no problem with them applying for a trainee license, or if they're beyond the trainee, then they can be considered for a full license when they are released. So that's the short version of what happens in OPOR. As I said, the other agencies within the department may have a very different process that they use for the same criminal record information. So at this point, I would like to ask Tim Tarano, I'm sorry, go ahead.
Yeah, I was just gonna give people an opportunity to ask questions before we went to the other speakers. Representative Pickett.
Thank you, and thank you for being here. I just on the 3-year look back.
Yes.
And I just want to understand. So if it's, I think the example you used was 5 years. So if there was a record that was 5 years prior to when you got the application, you wouldn't even bother looking into that record. It would have to be in the three years for you to consider that as possibly something that might disqualify. Am I correct in that?
That's correct, but I would add one thing to that, and I didn't offer this because it becomes really confusing. Each licensing board has a statute that lays out that board's authority. So there may be in that board statute grounds for discipline. So if there is anything in the board's statute that says, for example, if you're lack of truthfulness or fraud, those are considerations that a board can make, it can use in determining whether that person is qualified for licensure. It doesn't happen very often, but there are cases where a board has considered and placed some kind of limitation on the license that's being issued. It's hard to talk about this from my perspective because each case is different. Each applicant has a different background. So we're very careful about staying within the confines of the statute. But it's an excellent question. There's an interplay between a board's licensing statute and the chapter 341. So I was listening to Laura earlier, and the fact that these boards are not criminal justice agencies makes it much simpler. It's probably not a good word because it's all was complicated, but we just don't share the information that we receive.
Thank you. And that was helpful because I just wanted to make sure that especially if it was something that 5 year prior conviction or whatever record, if it was something that had to do with the job, with the license that they were applying for, there was a way that, and it sounds like we're going to hear about that
That's exactly
later.
right. And that happens sometimes in the real estate area where someone coming into the state has a disciplinary record or conviction in another state coming here. That is something that the commission itself could consider.
Thank you.
Mr. Morgan.
Thank you. Commissioner Head, I just have a question. It may be somewhat rhetorical, but my understanding of our duties is that they're fairly broad here. And part of them have to do with the effects that criminal records, including convictions, would have on all sorts of people, sort of people who are well-to-do and people who are not. Myself and my boss have had the pleasure to appear in front of some of the licensing boards. We represent people. And for the most part, you'd agree with me that these protections you're talking about that are built in apply to people who are middle class or in some instances fairly affluent, right? Doctors, nurses, plumbers, people who make a good living and can afford an attorney who can educate them about some of these protections, right?
I'm only going to speak to the professions that I have responsibility for, so not nurses, but everything else. No one is treated any differently depending on their background, their finances, their resources. They would all be treated the same way. And that is the value of the professional licensing system here. There is a level playing field, and our hope was to take off the table the question of criminal conviction right from the start, so that there would be a perception that we're not closing any group out, and everyone's treated the same way. Now, our licensing process is not designed to be a substitute for our judicial system. So everyone has the right to bring an advisor with them if they wish for that rehabilitation session, if that's, what actually happens. I think boards are very understanding of people needing to have a second chance at something. So,
Right, maybe my question was poorly worded, I guess, and we can cabinet to sort of the areas you're responsible for, but if I'm applying for a job at Target or McDonald's and have a criminal conviction, that's not going to make it in front of any of the licensing
Correct.
boards you're responsible for, right?
what kind, could you be more specific about what the criminal conviction was for?
What, I mean, it sounds like any of the ones you consider here, or why don't we put aside the sex offenses, because I think any of the pardoning laws we're looking at will, a misdemeanor theft conviction that involves dishonesty.
Well, it wouldn't matter to a licensing board if they were fired from another position. We're looking at criminal convictions that have happened and are concluded. Those are serious matters. We want to give them a way to show that they've been rehabilitated. I know, I have a feeling I'm not answering your question.
You're not, I think it's okay. I don't want to, we're moving along, and
Okay.
you've certainly provided good information and background, so I'll leave it at that for others who might have questions.
Okay, thank you.
Thank you.
So-
We have some more questions. I'm going to do the ones on Zoom, and then I do see Ms. Mancuso. So Foster Bates, I think you have a question from Commissioner Head.
Yes, hi. My name is Foster Bates. I'm the Maine State Prison NAACP president. I just want to thank everybody for this opportunity of being here today. My question is, if a formerly incarcerated person is denied an application, is there an appeal process? If so, what department does the appeal go to?
The application was rejected by a licensing board, is that what you're saying?
Yes, that's correct.
The applicant would have the right to, I'm not going to answer that question because I have no business answering it at the moment. Could I get back to you about that?
Yes, that's perfectly fine. And my last question is, what type of credentials are required to show that a person has completed proper rehabilitation programs? As you suggested earlier, that if he was rehabilitated, they can show those type of credentials and receive a license. What would that person need to show?
Generally, what happens at this point is someone will bring a parole officer, a counselor that they've been working with, depending on what the conviction was for. We will allow anyone to come with an applicant to make that case. So there are no restrictions on that. It is before the full board as an adjudicatory hearing. And whatever the decision is at that time, there's a range of decisions that can be made that would allow that person to continue working on a rehabilitation if the board is not convinced that that individual has now warrants the public trust. I mean, it's a heavy responsibility for a licensing board to have that kind of hearing. They take it very seriously, and they have been, I would say, quite liberal in allowing that person to become licensed, but maybe with a limitation on that license in the first licensing cycle. So we want to work with those individuals to make sure they're on the right track.
Thank you.
And Representative Talbot Ross, did you still have a question?
I did. Thank you, Madam Chair. I just wanted to ask a follow-up question to the one that Mr. Bates just asked. maybe for some clarification to Commissioner Head, and thank you for joining us today. I just want to make sure I heard you say that it's really up to those who are serving on that particular licensing board to make a determination if someone has met the level of rehabilitation that you all require, but those requirements aren't any, it's up to the interpretation of those who serve on that licensing board. There aren't any written standards around what constitutes rehabilitation within each licensing board. Is that right?
That is correct. The board certainly has the assistance of staff and legal counsel in that matter. But this is a process that is focused on the direct interaction between an applicant and individual board members. They want to see that person, they want to hear from them. And there's no limit on the range of questions that they can ask the applicant. So in that sense, I can't tell you that there are written considerations that every board member must follow because of the differences in the professions.
Right, Madam Chair, I just want to continue this line if I could.
Yes.
And that is then, I guess I'm gonna peel it back a couple of levels, and if it's up to the interpretation of the people serving on the board to determine if an individual has rehabilitated themselves, then I guess my question is there, and those standards for that evaluation aren't in writing, then is there some kind of training that our board members go through in order to know how to properly ascertain this? Or are we just assuming that they would be able to make that kind of a judgment?
I don't know that there is specific training that they have been given or an opportunity to have that kind of training as I'm sitting here. I know it has been discussed in the past, and obviously the person has to have been separated from this criminal justice system. So in other words, they have to have been released and given, their freedom. But beyond that, there is every licensing group has to make those calls based on their experience. And I'm sure if they have questions, they know where to get the support for their questions. If you're asking, is there a written set of criteria that needs to be complied with? I think I think we're guided by the criminal disqualification statute and what that says. I can go back to that part.
I think, Commissioner, where I'm going is if there's no written standards for trying to ascertain rehabilitation, and it's up to that licensing board to determine on their own, if we can put this on a parking lot, but if there's no training in this area, and perhaps we're not even considering in folks that we appoint to these boards, if there's nothing in that appointment around a requirement to understand rehabilitation, then I'm just trying to figure out how these individuals are able to determine if someone's been rehabilitated just based off of whatever they interpret. So we can put it on a parking lot, but I do think I'm glad that Mr. Bates raised this question, because the other thing that I'm cognizant of is that most of these boards are not very diverse in their makeup. And so if we've got, I'll just make it up, all white licensing board members who have not been trained in rehabilitation, or there are no written standards around it, and we've got a disproportionate number of people of color coming before these boards, then that's a concern for me as a legislator. But we can put that on a parking lot. There's a number of things in there that don't quite work without any written standards.
Well, I think for the most part, the boards will look to the applicant and ask, what have you done? And they give great credence to what the applicant presents to them. So it may not be showing on an application, but what they have done since they left the prison system is really important to the licensing boards. So I just offer that as a way of indicating also perhaps information on when these, I don't have it with me today, but if you think it would be helpful, I will do some research to see how many times in a period of time there is such a situation, if that would help in any way. And I do think this is something that the administration needs to understand as well. We don't have any authority for appointments, but I certainly do take your point on diversity.
I appreciate that. And I know other people want to ask you questions and we need to move on. My other question, and we can put it on a parking lot, and maybe we can get the answer by email to Commissioner, is around the time limitation for 10 years. I know that was set by the legislature, but I'm concerned that we just create these time limits without any science or data behind them. So there's the 3-year limit, but then there's this 10-year limit for all of these categories. And my question is, why 10? Like, what's the science behind 10? Why is it not 5 or 7 or 8 or 9 or 20? The 10-year limit, I'm just not, I don't see the.
And frankly, I don't have an answer to that. I wasn't around when 10 years was adopted. So that's a great question.
We can continue to look at it. Thank you very much, Commissioner.
Thank you.
Thank you. And Andrea Mancuso.
Thank you. I'm actually not sure that you're the right person to ask my question to, but I think one of the things that came up in the last iteration of this conversation that I think we still don't have clarity around is what is permissive and just like what have we created in terms of permission and discretionary considerations for criminal convictions, and what sort of have mandates around them that we need to be aware of. For example, the superintendent of insurance has a letter in the packet today that discusses some federal law that has certain requirements. Do we have something that cites for us what the federal law requirements are and the universe of that information? Because it sounds like for the occupational licensing board, there's a lot of discretion. They're entitled to get the information, but there's discretion about how to use it. And it sounds like you're not necessarily receiving confidential criminal history information now, you're just receiving the conviction data. So
right.
For us, if this committee is making a recommendation that certain convictions should go into the confidential criminal history bucket, the decision would need to be made around like, are those also sealed from you, or do you now need a statute that gives you permission to act? Is that's sort of the question that's on the table? And Petty, okay. Thanks, Peggy.
Is there a question in there, Ms. Mancuso?
If we have a list of the federal disqualifiers that are not permissive that we would have to pay attention to for the licensing. I know Ann Jordan raised a lot of them in the last iteration of this committee, of the things that we had to be mindful of for federal funding and those things. Like, what are the hard lines that we have to account for versus what we can recommend changing without putting up? Does that make sense?
It does. I think Commissioner Head wants to respond, but I think also Peggy has written that down as something that we need that information. Commissioner.
Yes, thank you. And thanks for the question. First of all, that is a question that should go to Eric Chapa and his staff at the Bureau of Insurance. I will say things are changing in the professional licensing world. Maine is one of the outliers. Most states require DOJ, FBI, criminal history checks on every applicant for licensure. O4 does not have that authority at all, never has. However, there is a new wave of licensing thought for which a licensure compact may be a way of addressing some of the issues. However, when you join a compact, a state joining a compact, for example, Maine is now part of SciPact, which is an interstate compact for psychologists. In order to be part of that compact, the board is required to have a DOJ FBI record check of all of our applicants. That is something entirely new. We have never been asked or given that authority. And I don't know why, but it's a reality today. The federal agency that oversees real estate appraisers today imposed the FBI DOJ requirement on all real estate appraisers in Maine. So there are certain agencies that we work with that think a DOJ criminal history check, which is what goes way beyond an SBI check, is necessary. We've never, we haven't embarked down on that path before. This has been imposed on us. And I don't know why. I think the variety of professions in this one agency makes it difficult to say which professions should be the subject of a more extensive criminal background check and which don't need to have that review. So there are many questions that lead into these discussions that I'm not aware of. I've never been a part of that, but I have worked with Representative Talbot Ross on these in the background. So they are very important. I don't know where we're going here, but we have never used the more substantive DOJ, FBI checks on our licensees. So I will have the Bureau of Insurance provide that information unless it's already available. I don't know. So we'll get it one way or the other.
Thank you, Commissioner.
Commissioner, very good to see you here. I'm Peter Lehman, Maine Prisoner Advocacy Coalition. You said that Maine is an outlier in terms of its licensing and its requirement. And what I hear you saying basically is that we're much more forgiving and liberal about the use of criminal history in doing it. I'm curious as to whether that would mean that Maine had a higher rate of misbehavior among its licensed professions, or whether we have a lower or about the same as other states. If you understand what I'm getting at.
I understand your question. It's a very good question because we've never studied the impact of what the system we use today, which doesn't appear to be as strict or rigid as states that use the DOJ that impose that requirement on licensees. So I've always thought, and I have been criticized, frankly, by other state regulators for not demanding a DOJ permission to look at every single applicant. I just don't it's not something I'm interested in doing because I'm not aware of a significant problem that I see in our licensing pools. Yes, there's maybe one or two people that get in trouble with the law. We watch that to make sure the criminal system takes care of it. I mean, sometimes there are situations where we ask for a voluntary suspension of the license when someone is definitely going to be adjudicated criminally. But that is so rare. We have like 112,000 licensees. I would say less than 10 have ever presented that problem. So I don't know how you make a judgment on whether we're too lenient, not lenient enough. It's so rare that we have issues. But this is a critical area for most states. I think if you look at the other states and what their license requirements are, you will see that that many of them, larger states maybe than Maine, have that requirement in their licensing statutes. So I haven't studied that, but I'm just going by my experience as a regulator.
Well, I would assume that the licensing boards themselves, when they are lenient about criminal histories, would keep a close eye on that. And have you seen any pattern of that turning out to be a poor choice?
I haven't. I
All
can
right.
say
So
that.
you're talking about tens of thousands of licensed people,
Right.
which is a pretty good sample.
Yeah, I think so. I mean, that number gets a little bigger each year. We're licensing more people and we're not seeing additional problems.
So in terms of criminal background, you're not seeing getting burned.
I do not.
Thank you very much.
Next, I see Judy Meyer.
Thank you, Madam Chair. I would just, a point of information, on the third page of Superintendent Chapa's letter, he does lay out the statistics. The last 5 years, 105, more than 105,000 license issued, 13 individuals were not licensed based on criminal convictions. So that number is calculated, and I would expect, because it's in his letter, it is being monitored.
Well, that's a separate agency from this one, first of all. So I have 110 different individuals that are licensed.
Okay, I thought somebody had a question on the Bureau of Insurance.
Yeah, we're going to get more information for the committee from the Bureau of Insurance, because there are some questions there.
Thank you. Matthew Ruel, did you have a question?
We're just a statement. Thank you. Ann, it's Matt Ruel. I just wanted to chime in on a couple of things that you had said. So I hate to use the kind of the term or terms of what's lenient and what isn't when we're talking about the DOJ check, which is really the FBI check. I would say that Maine is more of an outlier in terms of the amount of licensed types that require a state and federal check. I know there are some states, when you start looking at Florida and Texas and New York, that could have hundreds of different job types that require a state and federal check. And we've got a pretty small list. I submitted it. There's probably 10, 12 different licensing types that require a state and federal check. But the key purpose of the state and federal check is the idea of what happens in another state and getting access to that information. So if you run a Maine check only, you'll see Maine records that are publicly available. So if somebody happened to live in Kittery and had a criminal history in Portsmouth, you wouldn't see that information unless you ended up doing a federal check. So that's why a lot of states will end up doing a state and federal check. They want to make sure that they've got, all the information before they make their decision. We've heard the people say before, what happens in Vegas stays in Vegas. So the idea would be, we want to do a check to make sure that if something happens somewhere else, they've got that to make their decision. So I just wanted to point out that clarification as to how our stuff is set up around the federal checks.
Thank you.
Sure.
Any further questions? I have a rather simple question, or maybe it's not, going back to the opportunity of the applicant to show that they've rehabilitated sufficiently to warrant the public trust is what's in the statute. The statute also says that the registrant, the licensee, the holder, the one who has to show that they've been rehabilitated has the burden of proof. Can you just tell me what that burden of proof is? Is it a preponderance of the evidence, clear and convincing, beyond a reasonable doubt? What burden of proof do they have to meet?
I could give you sort of a legal answer about the two kinds of proof, preponderance of the evidence.
Yeah.
And
So I'm just asking what the
It's
applicant has
really-
to meet. What level is it?
I would prefer one of our
And if you
AAGs to
don't know, you
answer.
can get back to me, but go ahead. So,
I will certainly get you some information on that.
okay,
I think all of what that means is the burden is not on the state.
Right.
Once they see a conviction that falls within chapter 341 as it's laid out now. But even then, the applicant can convince the board by that presentation of what they've done since. So the board could make a decision in the applicant's favor if they are convinced. It's, I hate to say it, but it may be more of an individual. I mean, there has to be a board vote to do one thing or another. But I think the board members want to know more about that person and what they've done so far, what their plans are in the future. It's a whole range of personal information that they would like to hear from an applicant. I've had situations where a board has done exactly what they should do and allowed someone to be licensed with a couple of restrictions. If I were sitting on that board, I probably shouldn't say this, I might have made a different decision. But these boards know what they're doing, even though it's not written out for them. So training is wonderful. I will certainly take that into consideration. If we have money to do that, I think that would be an excellent idea, along with diversity training. So you've given me a lot to think about, and I appreciate that, because this is an important area.
thank you, Commissioner, and I appreciate that. I think that my questions, and perhaps Mr. Bates and Representative Talbot Ross, is we're really trying to understand the process. And so understanding, again, what the standards are, what the burden of proof is, what, if anything, is available to the applicant who's been denied to appeal. And of course, if there is an appeal, I know the court is going to want to know what are the standards, what's the burden of proof. So I think we just need more information on the process is what we're trying to get at. Representative Pickett.
The appeal process that was brought up and the question was asked on page 3 of your handout, it talks about the appeals portion of it. So there obviously is an appeal that talks about, it says any person who is aggrieved by the decision of any licensing agency in possible violation of this chapter may file a statement of complaint with the district court designated in chapter, and it goes on and gives chapter and verse. And the reason I mentioned that was to kind of get that on the table, that
Yes,
we
you're-
now know there is an appeal process, but I'm wondering, and you may not have the answer to this, but I'm wondering if we can get that, if we can get some kind of data on how many, if any, appeals have actually been made, maybe over the last several years to the agency on a decision that was made, that might be helpful
Sure.
to us. Thank you.
I'd be happy to do that. And the burden of proof, burden on the applicant is, if I could just go back to that one question. Many of, I mean, the typical person who's in that position does not have a lawyer, but they do have other people that they've been working with. So it's not a legal concept at all. It's what this person can show that they're prepared to do, or that they have done since they left the system. So it's hard to say what the legal, what does that mean? It depends on the situation and the person that's standing, that's answering board questions.
Thank
But
you.
I get it. I understand what you're saying.
Thank you. Further questions?
Can
Andrea?
I ask a question of Director Well, of Matt? He was, okay.
Representative Talbot Ross?
Yeah, I appreciate the discussion, and again, want to thank the commissioner for being here. I am happy to hear about the consideration of perhaps some training that may need to take place, but it goes even further and deeper than that. It's who we choose to sit around these tables that make these decisions. And so again, on a parking lot, if we're taking minutes, I just want to make sure that we highlight the fact that it's not just about a diversity training or some indoctrination into that. It is much deeper. It has a root in who gets to make these decisions to begin with, and the composition of those people, which I know Commissioner Head has already said that's not part of her authority, but it is something that this commission should be well aware of. And the other thing that I would make note of for a parking lot is I hope that we don't get trapped in the data that Judy Meyer had put forth and think that the absence of a large number of appeals or a large number of cases going forward, it means then that we're doing the right thing. There is no magic number here. If somebody is not given the full opportunity that they deserve to practice in a profession that they may be qualified for. So I just want to make sure I'm not going to get trapped in there's only 1 out of 1,000 or 5 out of 5. I'm not going to get trapped in those numbers. And I hope that we don't as a committee, because that is not a proxy for whether or not justice has been served. So thank you.
Thank you. Commissioner?
I understand exactly what the representative means. And I would like to say that I hope this has resources to devote to that kind of study. I can't do that. I don't have the staff. Are there resources for that kind of research? I hope so.
Thank you. So in the interest of time, so I think you do have some other speakers, and we do want to hear from them. I would ask them to really just focus on areas that we haven't hit upon already and specific to their areas. So who did you want to invite next?
I believe Tim Terranova from the Board of Licensure in Medicine is the next speaker.
All right, and is he
Thank you very
here
much.
or is he on Zoom? I'm gonna ask now. Okay, so, all right, there he is. Thank you. Welcome.
Thank you. Good afternoon, and thank you for inviting me to speak with you this afternoon. My name is Tim Terranova, and I'm the Assistant Executive Director for the Board of Licensure in Medicine. The board licenses allopathic physicians, which are MDs, and physician assistants, or PAs. The board does not routinely perform a criminal background check for all applicants for licensure. Instead, it asks whether they have been convicted, arrested, charged, or indicted for any crime, as certain crimes may constitute grounds for disqualification, and or certain conduct that underlies the criminal conduct may constitute grounds for disqualification. Most applicants for licensure disclose their criminal record histories, and by and large, the board does not deny a medical or physician assistant license based on a criminal record history. It is rare for the board to deny an application for licensure as it believes that people can be rehabilitated. Examples of criminal conduct that are of concern to the board include OUI, DUI, which may be indicative of an underlying substance misuse disorder, Medicaid or Medicare fraud, which is indicative of a lack of trustworthiness, drug trafficking, for example, selling prescriptions of oxycodone, or sexual misconduct. The board does require applicants for letters of qualification pursuant to the Interstate Medical Licensure Compact to complete an FBI background check. The purpose of the check is to ensure that when physicians move from one state to another, which is happening more and more with physicians who work for travel companies, the receiving state will know that the physician does not have any criminal convictions of concern to deny or delay the expedited licensure. The board comes into possession of criminal record information in various ways. We have rules that require licensees to notify the board within a certain period of time of a conviction through licensure and relicensure, and through other state and federal agencies, such as the AG's office, police departments, or district attorney's offices. One quick example of how this information is used, just this past year, we had an applicant for licensure indicate on their application that they were convicted of a charge of trafficking to one patient 11 years ago, that they had no issue since then, and that their record was clean since that time. The information was requested to corroborate or contradict that assertion. And the information demonstrated that not only did it involve many patients and non-patients, but that it went on over a course of a period of time, involved people coming from other states to purchase the oxycodone prescriptions, getting them filled, and then returning to their home states, and that thousands of dollars in cash and a firearm were seized from his home. In addition, it also revealed that the last 10 years of his no problems with practice was because he was actually in prison. And that is a concern regarding safety to patients of Maine. The last thing that I would say is, prior to releasing any criminal background check information, the board checks with its assigned assistant attorney general. And again, that's prior to releasing any kind of information to the public to request. And I know that you're running a little behind, so I thank you for the opportunity to speak. I'm happy to answer any questions. And if there are no questions, then I would turn it over to Judy Shaw.
Thank you, Mr. Tarano. Any questions from committee members? Seeing none, thank you. And I think next we're going to hear from Judith Shaw. Welcome.
Thank you. Good afternoon. I appreciate the opportunity to speak with you this afternoon. My name is Judith Shaw, and I'm the administrator for the Maine Office of Securities, and I want to talk to you about this important investor protection. By way of background, our office operates under the authority of the Maine Uniform Securities Act, which is a uniform law approved in 2002 by the National Conference of Commissioners on Uniform State Laws and was enacted in Maine in 2005. This is a law that's been adopted by securities regulators by states across the country. When we license securities professionals, a key tool in fulfilling our mission, which is very simple, to protect Maine investors, the Act authorizes the administrator, currently me, to deny, condition, or limit licensure based on an applicant's criminal history record. I can take action against an applicant if the person has been convicted of murder or a class A, B, or C crime, or if within the previous 10 years, the person has been convicted of a class D or E crime involving a security or other investment-related misdemeanors. Further, the Act authorizes the administrator to consider any crime indicating a lack of fitness to engage in the securities business, which would encompass crimes like embezzlement or forgery, for example. We utilize a standardized electronic licensing and registration system, commonly known as the CRD, It's used by the industry and by state and federal regulators, including the state of Maine, and it allows applicants to submit their applications and seek licensure in the jurisdictions they choose, which sometimes includes all states and very often includes all of New England. The application requires applicants to disclose information about felony and certain misdemeanor charges and convictions. In 2020, the Office of Securities received 23,695 applications for licensure as a broker-dealer agent, and we automatically, or the system to be more accurate, licensed 21,496 of those individuals. Another 2,079 of those applicants whose licensing history required additional review, and that would include not just criminal history, but other disclosures. They were licensed within 24 to 48 hours of submission. Of the 23,695 applications, only 120 applications required additional scrutiny. It's important to emphasize that an applicant who has a criminal charge or conviction is not automatically sanctioned or barred from licensure. When reviewing applicants who have disclosed a criminal history, we focus on the most serious felonies and crimes that have a direct correlation to the financial services work we regulate. In those few instances when licensing action, which would be denying or conditioning a license, is deemed appropriate based on an applicant's criminal record, the applicant is always entitled to due process in the form of an administrative hearing on the proposed action and a subsequent right of appeal to Superior Court if they are dissatisfied with the administrator's determination. To illustrate the importance of consideration of these crimes in the licensing context, I offer as an example, former legislator and licensee Ken Lindell. Mr. Lindell was an agent of a broker-dealer who ingratiated himself with two elderly women and stole over $3 million of their money. Mr. Lindell was convicted of 15 counts, including theft, securities fraud, and tax charges, and he is currently serving his prison sentence. But if he were to apply to become licensed again after his release, it would be important for the administrator to be able to consider, among other things, his conviction when determining his fitness to engage in the securities business. Regarding further disclosure of criminal history information, applications for licensure, including any criminal history disclosed by the applicant, are considered public under the Uniform Securities Act, specifically 32 MRS Section 16607(1). If we've received a request for an individual's license application, that application would be disclosed pursuant to subsection 16607(2)(e). We would redact any social security number, residential address, and residential telephone number. Application information is also generally available on the publicly accessible broker check and investment advisor public disclosure websites maintained by the federal regulators. The information contained in an application about charges and convictions is reviewed by the federal authorities, who decide what public disclosure will be made on those websites based on the type of charge or conviction and when it occurred. Thank you very much for your time this afternoon, and I'd be more than happy to answer any questions you may have.
Thank you, Administrator Shaw. Any questions from committee members? Looking, I don't see any. Oh,
Yes,
go ahead, Michael.
thank you. Would Judith Shaw and the other presenters mind sharing any of their presentations if they have it in a written format? They're comfortable emailing it to the group.
I'd be happy to.
Great, thank you. And this also goes for the previous presenters if they're okay doing that.
Right, thank you.
Thank you.
You can just send those to our analysts and they will disseminate. And also, I assume you would post them on the website. Thank you.
Very good. Thank you.
Any other questions for Administrator Shaw? Seeing none, thank you. And I see Christine Fournier has turned off her video and unmuted herself and is ready to go. Thank you and welcome.
Thank you for having me. Good afternoon, members of the Criminal Records Review Committee. My name is Christine Fournier, and I am a principal examiner with the Maine Bureau of Consumer Credit Protection. We are a small agency of 15 employees, but we are responsible for licensing more than 20,000 companies and individuals that provide financial services to Maine consumers. We regulate a wide range of company types, including mortgage lenders and servicers, student loan companies, auto dealerships that sell vehicles on credit, money transmission and virtual currency, debt collectors, repossession companies, credit reporting agencies, and even pawn shops located in this state. I'm going to attempt to share my screen with you for a moment. And this may or may not work. Okay. In certain business categories, state law permits our office to require that applicants provide authorization to submit to criminal background checks. Today, I wanted to highlight why such requirements are, in our opinion, appropriate, and the process of working through what's involved in conducting the criminal background check. First, the application or the applicant is provided with a list of prerequisites of what they need to do to obtain the license. A criminal background check is often one of those requirements. And we'll use the example of a mortgage loan originator. This is an individual that collects personal information from a consumer, such as date of birth, social security number, address, tax information, and more. The mortgage loan originator would collect this personal information in consideration of a loan application to buy a new home or to refinance a mortgage loan. Because of deceptive or fraudulent activities perpetrated by some individuals or companies, federal and state laws were enacted to require the authorization of a criminal background check. Sticking with the mortgage loan originator example, Maine's licensing law is patterned after federal law and matches the laws of the other 49 states as well. In fact, the Bureau is required to conduct criminal background checks because of federal preemption. Therefore, consideration of waiving certain requirements of the application process, including conducting criminal background checks, is not something that we have the authority to do. There is a 7-year look-back period for preceding the date of application in the instance of mortgage loan originators. But felony convictions involving an act of fraud, dishonesty, breach of trust, or money laundering can be considered at any time in the past. For example, felonies involving financial crimes, such as embezzling a consumer's funds, may be grounds for automatic disqualification. Regardless of the findings, an applicant always has the opportunity to explain items in their criminal history and also has the opportunity to appeal a Bureau's decision. The criminal background check process can be done through the nationwide multi-state licensing system, or what we call NMLS. Applicants are given detailed instructions about how to complete the process and are also provided with disclosures about how the results will be used. The applicants are informed that they have the ability to provide documentation or explanations to go along with any result that is reported if they choose to do so. The material is never made available to the general public or anyone else without expressed consent and authorization. Why is it important to conduct criminal background checks for mortgage loan originators? The answer becomes clear when you consider that these individuals have access to all manner of consumers' identity and financial information, including credit reports and income tax returns, everything needed to defraud a consumer or assume a consumer's identity. Maine also gives our office the right to obtain criminal histories of employees who conduct repossessions of vehicles in the state because of the potential for a confrontation between repossession agents and consumers, and the principles of debt collection companies, since in the past, creditors were harmed when collectors obtained money from consumers, but then embezzled the funds rather than turning those funds over to the creditors. Thank you for your attention, and I'd be pleased to respond to any questions you may have.
Thank you. Any questions from committee members? Andrea?
Thank you, Madam Chair. So you've mentioned that you have the right to obtain criminal histories and are required for some of those occupations to obtain background checks. And then some of the convictions may be grounds. Are there any of the convictions that you look at that are automatically grounds for disqualification, that must be grounds for disqualifying?
Not that must be, but anything that's a financial related crime, such as embezzlement, wire fraud, money laundering, anything to do with a misfiling of a bankruptcy in a fraudulent way, fraudulent types of crimes we do consider, but there's not any absolute, we will not do it crime.
Thank you.
Thank you. Further questions from any committee members? I'm looking, I don't see any. Thank you, Ms. Fournier, and thank you all, Commissioner Head and all of the presenters. I think this has given us a lot of information and a lot of food for thought in helping us to understand that it's not just the criminal justice system where criminal records are used and considered. So I know I found this very informative, so thank you very much. Moving on, next on the agenda is Tessa Mosher, Director of Victim Services, Department of Corrections, discussing the victims' perspectives on record clearing and sealing laws. And there she is. Welcome.
Thank you. I would like to thank the chair, Senator Donna Bailey, and Representative Rachel Talbot Ross, the Criminal Justice Records Review Committee, for the invitation to speak on victims' perspectives regarding sealing records today. I'm honored and humbled to have the opportunity to speak with you today. I was asked to provide some information about the perspective of victims of crime pertaining to the discussion of sealing criminal records. And I did want to mention that I know with some of the presentations today, it was very specific to some statutes, but my presentation is a broader overview of the victim's perspective. And so I am Tessa Mosher. I am the Director of Victim Services at the Maine Department of Corrections, which I will refer to as DOC OBS. And I've worked with the department for over 20 years. I have a degree in criminal justice, and I have previously worked as a county jail corrections officer, a dispatcher. I was a victim witness advocate at the local district attorney's office prior to coming to the DOC. And I've worked with thousands of crime victims over the last 25 years. I represent the DOC Office of Victim Services, and I'm speaking on behalf of the victims based on my experience in working with crime victims. And I would like to provide you with some general information about victim services and the needs of crime victims, again, in my experience. And I'm not speaking in favor of or in opposition to any specific bill or legislation. I'm going to share information with you about the DOC Victim Services and the importance of victims and criminal justice agencies having access to criminal justice system information and records related to the crimes committed against them, along with a snapshot of a broad perspective of crime victims' positions. The information shared about the DOC OVS, according to my experience, is to give you the perspectives of how our criminal justice system relies upon criminal records and criminal justice agency information to advocate for and assist victims of crime in safety planning. When I refer to crime victims, I mean according to the statutory definition, who is eligible to receive victims' rights according to Statute 17A in Section 2101. In my experience, victims are easily frustrated due to the slow pace of the legal system. They have to wait for the investigation to be done. They have to wait for the court proceedings that regularly get continued. They have to wait for the final outcome. And sometimes they're not given specific information about any charges being filed or the final outcome of the case involving them. Once they call wanting answers, they do expect that the information is readily available to them to be able to assist them quickly. They want timely responses and specific answers about the status of their case and what it means. Explanations are important. It's important to keep the victims informed of the status of any and all legal proceedings, and it's equally important for other providers working with the victim to understand the complexities of the legal process, including post-conviction, which is what we generally work with. Often victims call wanting information and they're upset and sometimes terrified, waiting on the information needed before they can act and make decisions to proceed with any given situation. To victims, this information they have been waiting on can decrease their anxiety about the issue or that they're calling about, or it can even, if it doesn't get answered timely, can cause crisis. Among the most significant DOC OVS priorities is the delivery of accurate information from court documents and status information such as length of sentence, release date, probation conditions, resources, and other information available to them. We want the response to victims by the criminal justice system and communities to be effective and lead to fewer crimes, and that the programs assisting victims are at the highest quality. At the DOC OVS, we provide advocacy to all crime victims, regardless of the crime type or age of the person committing the crime against them, according to statute, especially if the defendant is the care of or the custody of the Department of Corrections. The DOC OVS advocates for crime victims while ensuring their rights are met according to statute, policy, and procedures, while treating them with dignity and respect as the law requires. A few basic services we provide for victims is victim notification of release from incarceration upon request, safety planning, referrals to other victim service agencies and other agencies as applicable, information and education about the criminal justice system, information and explanation of criminal justice documents such as judgment, commitment, probation conditions, and provide a copy as requested. We provide victim advocacy and assistance with harassment and much more. It is important to remember that every victim's impact is different and that the impact varies from minor victimization to an extreme lifetime of fear and trauma caused by the crime. Victims' positions vary, and there is not one solution that fits all. Crime may not define a victim, but they still want to believe in our justice system and be afforded the basic rights, such as criminal justice information and related documents and records pertaining to the crime that was committed against them. The victim's loss and trauma and impact on them due to the crime never fully goes away, and they are left with this impact throughout their lifetime, or a loss that may never be fully repaired. Although each victim can have different thoughts about the criminal justice system, there are similar thoughts they share, and I'll do my best to share those similar thoughts with you today. So from my experience, in order to assist a victim, every step starts with having the criminal justice agencies having accurate information and case histories to make informed decisions to best benefit the victim and public safety. In order to assist victims properly, access to case information is required. This is the point where I'm just going to know the victim's beliefs and so forth regarding some topics pertaining to this matter. So criminal justice victims believe that criminal justice information records are at the heart of victims' rights and services available to them, and it's according to statute. It would be bad public policy decision to prohibit them from obtaining access to criminal justice records. They should be given access to criminal justice related documents related to the case committed against them. Their safety should be the priority. In order to make the best considerations for their safety, they need as many facts as possible. Their rights should be balanced with the defendant. The information should be informed, and they should have opportunities to provide input regarding decision-making. They want the criminal justice agencies to always have accurate records to make the most informed decisions to protect the victim and public safety. It's imperative to have a complete and accurate information about the crime committed against them to have access to the criminal justice related documents pertaining to the crime long after sentencing. They want other agencies to have a part in assisting them in their safety and to reduce additional harm to have access to the case information. Other direct stakeholders have easy access to the information in order to assist adequately and provide necessary support and resources to assist the victim timely and appropriately. They want to be compensated promptly for their out-of-pocket expenses and to have information available to them about the crime in case they need it to file any form of a civil suit, share with insurance companies, have available for any other need in order to be compensated. Minimally, the information should be available to them until they are at least compensated in full. There should be professional victim advocates to accurately explain the criminal justice system and resources available to them in an understandable way. And they should be treated with dignity and respect without judgment or blame. And they also want to have no other harm caused to them or anyone else. They would like to have their victim contact information confidential and not shared with the public. And oftentimes with victims of sexual assault, they have asked for the original charges to be made available, regardless of a plea agreement, in order to protect the vulnerable, including children. Victims believe this should be available in the case the defendant is applying for jobs that may require them to work around children. In closing, in order for any victim to have their rights met, questions answered, proper advocacy, and possibly beginning healing, they must have an outlet to obtain accurate information. Other criminal justice agencies must also have that information available to them to make informed decisions about the victim and public safety while assisting. And now that you've heard from the perspective of the victim, I am also willing to obtain any other information or provide any information from my experience that you might find helpful in your work. And I, again, am extremely thankful for your time today.
Thank you, Director Mosier. Are there any questions from committee members? Mr. Lehman.
Director Mosier, thank you very much for being with us today. I appreciate your coming and I appreciate the work that you do. I'm just a little confused by some of what you've talked about, the generalizations that you made about victims wanting this or wanting that or feeling this way. And I'm not quite sure who you're talking about. If I understand your office correctly, the people who you have contact with are victims of those offenders who are incarcerated with the Department of Corrections. And what percentage of victims in the state would that be?
Thank you for the question. That's excellent. I would like to confirm the Department of Corrections Office of Victim Services does in fact work with crime victims of all crime types whose offenders are in the care or custody of the Department of Corrections. And so in my 20 years of experience with working with victims of crime, that's where the majority of the positions have come in my experience working with them directly. And so I don't have specific percentages for each number of those that might be related to someone that's incarcerated from over the last 20 years. But I can say that those are generalized perceptions of victims according to my experience in working with them. And again, there's a wide variety of different perspectives that people have had over the years, but those are the generalized basic thoughts of multiple victims that I've worked with over the years.
So if I understand what you're saying, you're referring to the people who have contacted you for victim services, and that would mean in the Department of Corrections, that would mean about 5 to 10% of crime victims. have offenders in the DOC?
I don't have the sorry about that. I don't have the actual percentages. And again, it was based upon my experience at the Department of Corrections and working with thousands of crime victims over the last 20 years. And prior to that, as a victim witness advocate in the district attorney's office. So no, I cannot speak for all crime victims. It was just my information based upon my experience in working with victims that have primarily contacted the Department of Corrections Office of Victim Services.
Okay, I appreciate that. I just wanted to get us some context about the general statements about victims, because what you're saying, if I understand correctly, is that you're talking about the self-selected portion of those victims from the 20% of victims that have who have offenders incarcerated in the DOC.
Yes, you're correct that the information that I've shared is due to the contact that I've had with victims of crime while working in my position at the Department of Corrections and then at the District Attorney's Office as a victim witness advocate. And so we do reach out to crime victims. So it's not always a opt-in process, but again, it is my experience from those that I have worked with while at the Department of Corrections primarily. I hope that answers your question.
And the victim services that you offer include rehabilitative and support groups and restorative justice circles for victims to heal their trauma?
Our office is outlined according to statute on what services we provide, and we do not offer support groups. However, we do have general referrals that we provide when there might be a domestic violence or sexual assault case, and we refer to the coalition agencies for the domestic violence resource centers or the sexual assault centers across the state of Maine. So we do not provide those services directly. However, we do provide safety planning upon a release once a victim may request that. We also provide information and resources to other services that might be available to them across the state and as applicable. And so that's something that we do provide. A lot of the information that we provide is information according to the statutory victim's right and the actual notification of defendant's release or escape. And that's primarily the notifications that we do send out. And again, those are upon request. However, we do reach out to crime victims in many other scenarios as well, and offering a victim-centered approach in ensuring that victims know what their rights are, and also knowing what services are available to them and their ability to request victim notification of release, as well as opt in for other services that we may also offer at the department.
Thank you so much. And I do appreciate the referral work that you do. And I know that you have a great deal of effectiveness in that. I was curious about your connection with the criminal records that we're talking about. You suggested that those criminal records being public was very important for the victim's safety. And I wondered if you would explain what you meant by that.
In order for a victim to make the most informed decisions for themselves, they lots of times need to have access to the information about what the final outcome was with the case. And so it may be a matter of sharing information about what took place at court what the sentence was, which so then they can actually determine when a release date might be coming. And so that's information that we do share with them. So the information that they request always goes back to what took place with the beginning of the crime, and then ultimately what was the final outcome. And that information can be shared with victims so that they can make the best decision for themselves. So for example, if there might be probation conditions in effect upon release, then the victim could use that information to know that there might be a no contact condition in place, or they may know that there's not to be some sort of other parameter, such as no use or possession of alcohol, etc. And so the victim is able to use that information in their own safety planning. And then also, if there happens to be other information from the crime that they might be able to use when safety planning with law enforcement or with probation or with other advocates, then they can use that information to make the best decision for themselves, because it's ultimately up to them to make that final decision on what they think is best. And they use the information in order to make those decisions. And so when I talk about public safety, I mean, when we are working with a victim in order to make the best decisions for them, law enforcement is lots of times involved, as well as probation and such. And so it's an informed decision on what to do or what they would like to do. And it basically relies on the information based from the conviction.
Okay, thank you very much. I appreciate that. I wasn't aware from our conversations with SBI that probation conditions were part of what you got from a criminal background check. Should somebody check on that? Because I'm not sure that that's public, and I just don't know. That's confusing to me. I'm not sure whether or not that's public information.
Andrea Mancuso.
Thank you, Madam Chair. I just appreciate Director Mosier being here today and her acknowledgement that at the outset of her presentation that serving victims and identifying victims' needs is not a one-size-fits-all approach. And I just hope that we as a committee can appreciate the difficult task she was given here today to represent the perspective of victims, and that there isn't one agency or individual that represents or works with all victims in the state. So I hope that we can appreciate that she's giving us her perspective from her years of expertise, and credit her with having acknowledged at the outset that coming forward with a victim voice perspective is a very difficult task.
Thank you. And yes, I think Director Mosier made that very clear on numerous occasions, that she's giving her perspective based on her experience, which is quite vast and knowledgeable. And so I appreciate that. Further questions from the committee? Seeing none, again, thank you very much, Director Mosier, for that important information. And next on our agenda, which may be our final agenda item, we'll see, is Michael Hartman from National Conference of State Legislators.
Hello, thank you for having me. Let me go ahead and pull up some slides for you all. Are you able to see them?
Yes, thank you.
Perfect. So thanks for having me speak today. My name is Michael Hartman, and I am a policy associate in NCSL's Civil and Criminal Justice program. I do have a bachelor's degree in psychology and a JD from the Stern College of Law here in Colorado. With that said, I do want to be cautious of your time. I know we're running out, so I will try to keep this presentation really quick as we speed through, and then we can do as many questions as possible at the end. So without further ado, let's begin. Today, I'm going to talk to you about three main topics, which I've broken down on the slide for you here. First, we're going to discuss some of the differences between record clearing and pardoning. From there, we will discuss the different types of record clearing options throughout the country. Next, I'll discuss some of the different processes that states are implementing for record clearing. I'll attempt to provide some comparative information for you as well. And finally, I'll give some examples of what other states consider to be eligible offenses for record clearing and what they deem as ineligible. So first, let's talk record clearing versus pardons as they relate to record clearing. Both can be used as tools to help individuals suffering from collateral consequences of conviction. However, there are some key differences. Many states, like Maine, reserve the pardon power to the executive branch of government. With that said, there are also hybrid systems, which include legislatures to some extent, and systems that use independent pardon boards. Additionally, pardons do not clear the conviction from public record and act more as a forgiveness for the crime than as record clearing. I won't speak too long regarding pardons, as I know a lot more information about record clearing generally, but I do like to compare pardons to more closely with certificates of rehabilitation rather than record clearing itself. Much like the certificates of rehabilitation, the criminal record stays intact. However, collateral consequences from that conviction may be wholly or partially removed. With that said, let's dig a little bit deeper into record clearing more. First, terminology. So as you can see on the top of the slide, I've given the Black's Law dictionary definition for many of the terms used in record clearing laws. Unfortunately, most jurisdictions mix and match this terminology and meanings regularly, so there really is no uniform definition for each of these terms. With that said, I would describe most record clearing laws as sealing laws. Sealing, as opposed to destroying, does give jurisdictions more control over what the records might be used for at later dates, such as during subsequent criminal offenses, for jury duty eligibility, or even to continue certain collateral consequence restrictions, such as those placed on voting or obtaining concealed carry licenses. In previous generations, where actual storage space was an issue, keeping all these records could become a logistical nightmare. However, with modern storage file systems, there's virtually no limit to how much information can be kept by the governments, pretty much indefinitely. With that said, let's go ahead and take a look at a few state examples to see how they differ in their terminology. As you can see, I've selected 3 terms to discuss in a little bit more detail. I chose these 3 as they are the most common ones used throughout state statutes. However, keep in mind, there are definitely others. First up is expungement, perhaps the most common term used. I've got 2 quick examples. First, under Delaware law, expungement means all law enforcement agency and court records, including any electronic records relating to a case in which an expungement is granted, are destroyed, segregated, or placed in the custody of the State Bureau of Identification. In contrast, under Indiana law, expungement only prohibits the release of the person's records to anyone without a court order. Additionally, in Indiana, expungement of a crime of domestic violence does not restore a person's right to possess a firearm, one of those kind of additional collateral consequences not removed. Next is sealing, sometimes called shielding by some states, perhaps the most common result of record clearing. Despite the terminology used by states, like I said, expungement is often used. However, it functionally acts more like sealing laws very often. Under Arkansas law, for example, sealing means to expunge, remove, sequester, and treat as confidential the record. This typically does not actually involve physical destruction. Additionally, sealing in Arkansas does not reconfer the right to carry a firearm if that right was removed as a result of a felony conviction. Furthermore, a sealed record can still be used in certain court proceedings, such as to determine habitual offender status, and may still be examined when applying for licensure from a healthcare agency or for a position in law enforcement. Colorado is a little more explicit with who sealed records can be shared with, including law enforcement agencies, criminal justice agencies, prosecuting attorneys' offices, or agencies required to conduct a criminal history record check on an individual. Again, physical destruction of the record does not occur in Colorado. Finally, set aside, also a commonly used term. Michigan's set aside allows a conviction to be considered not to have occurred, with some exceptions, primarily around sex offender offenses. Nebraska's set aside nullifies the conviction and removes all disabilities and disqualifications imposed. What this means is that, among other things, a person with a nullified felony conviction regains their right to be a part of a jury and right to hold public office, which is often limited. As you can see, most states do not physically destroy records, so that is not very common, as the term expungement might suggest. However, many even keep these records specifically to make sure that they can have certain collateral consequences in place following record expungement or removal. But with that, let's move on to how states are implementing that kind of through processes. But before we get into processes too much, I did want to highlight a study that looked into this very issue back in 2019 and caused movement in Michigan. So in a widely acclaimed University of Michigan study, research looked at uptake rates. This is the rate at which eligible individuals received record clearing in Michigan's set-aside system, which is a petition system. The results were fairly disheartening regarding the petition process. Only about 6.5% of eligible individuals received record clearing within 5 years of the date at which they first qualify. The research determined that the low rate can be primarily attributed to individuals' failure to apply rather than to denials by the agencies of applications. The study also looked at recidivism of set-aside recipients, looking towards that public safety element, with just 6% of all set-aside recipients being rearrested within 5 years of receiving their set-aside. The study also looked at employment and record clearing and found that 1 year following a record being cleared, people are 11 times more likely to be employed and are earning 22% higher wages. Michigan's study was looking at their petition-based system to see why it wasn't working in the way they had intended, as there are so many eligible individuals who weren't actually receiving their records clearance. So other studies have also shown that when a person is eligible to get their record cleared, only about 10% actually do through petition processes. So that's not a very large percentage. Given these low uptake rates, state lawmakers are increasingly interested in statutory provisions that automatically clear a person's criminal record. While many states have on-petition laws, these laws typically require the individual to petition the court and pay a fee for clearing a criminal record. Making this procedure automatic, however, removes the need for a petition and is often done free of charge to the recipient themselves. Currently, 20 states have at least one statutory automatic record clearing provision. Michigan, New Jersey, Pennsylvania, and Utah have enacted legislation that automates the automatic record clearing process, sometimes known as clean slate laws, or what I refer to as automated as opposed to automatic. For more information on each of these states, I would recommend visiting NCSL's record and reentry homepage. We do have policy snapshots that do a little bit more justice to each of those 20 states with automatic record clearings, and we have a graph that you can check those out. But with a lot of the science around the policy out of the way, let's take a deeper dive into the processes themselves. So with regard to automatic versus petition systems, states vary widely. I've given general definitions on the slide, but one key difference is that on-petition record clearing provides a forum for objectors, typically a hearing, whereas automatic and automated record clearing is streamlined for efficiency and does not always provide that opportunity to object. Keep that in mind, as we will cover an automatic system which does provide an opportunity to object, however, is still streamlined in comparison to a petition process. So speaking of streamlining processes, recently some states have actually made efforts to streamline even their petition processes. For example, Colorado requires the court to grant a motion to seal records without an opportunity for the district attorney to object, but only if the person has not been convicted of a crime since final disposition or release from supervision. And then along those similar lines, Utah recently eliminated the requirement for a certificate of eligibility, which was kind of the first step in their process, which ultimately streamlined their process as well. With that said, states are continually moving towards automatic or even automated systems for appropriate offenses. The major difference between the two being the use of technology and the hands-off nature of automated systems. With that said, it's worth noting that the cost to create automated record clearing is still rather steep upfront. According to recent research surrounding Pennsylvania's enactment of automated record clearing, fully automated systems cost approximately $2.96 per person after an initial $3.4 million to set up the system for an estimated relief population of about 1.15 million. Comparing that to a legal clinic assisted petition-based record clearance process, which would be about $3,757 for that individual. And then if you do not have legal assisted clinics, that petition process cost is going to go even higher as additional attorney's fees kind of play in there. So as you can see, the upfront costs to automating the system can be expensive, but the ongoing costs following implementation are marginal in comparison to traditional on-petition costs, at least when you look at it by a per record or per person standard. With understanding some of the differences out of the way, I'm going to move on to how states are drafting their eligibility. I'll be focusing on a handful of larger enactments, but keep in mind, each state has very unique nuances and eligibility requirements. They can also change depending on the process being used. For example, some states will use automatic record clearing for lower level offenses, or automated for records that were recent enough to be stored in completely electronic formats, but keeping that petition or automatic system for those stored in older forms that might require a little bit more hands-on work. So first up, I do want to talk about Pennsylvania. It was the first state to enact a clean slate law. The simple summary of this law is if a person committed an eligible offense and stays conviction-free for 10 years, again, there's that 10 years, then your criminal records will automatically be shielded from public view. Here's our first nuance. If a person commits certain minor offenses within that 10-year timeline, it will not count against them, so that 10 years will still be counting. Like I mentioned earlier, many of these laws have very specific nuances, so just know I'm talking in broad strokes here. In almost everything, you could have a little bit of an asterisk on, so to speak. As you can see on the screen, second and third degree misdemeanors are eligible, as well as some other low-level misdemeanors. What you'll see commonly included in non-eligible offenses is sexual offenses. One interesting inclusion that is not as common is Pennsylvania's inclusion of cruelty to animals. With that said, keep in mind, these records will not just go away and disappear everywhere. They will still be accessible to law enforcement and judicial officers. Like I said, Pennsylvania's law acts as a shield from public view, not a full expungement or destruction of the record. Next up is Utah, which also passed a clean slate law in 2019. Implementation took place in 2020. Under Utah's new law, traffic offenses are actually the only ones eligible for automated relief. The remainder are automatic, with judges being required to enter an order. Under the automatic offenses, prosecuting agencies will receive notice of eligible cases monthly and have 35 days to object under a set of enumerated circumstances. So essentially, this is that implementation of an automated system or an automatic system that kept that opportunity for an objection by the prosecutor. So in addition to the offense eligibility on the slide, a person must be crime-free for 5 years for a Class C misdemeanor, 6 years for a Class B misdemeanor, and 7 years for drug possession, which is the only Class A misdemeanor that is eligible. That's why there is an asterisk there. As you can see, offenses such as sexual battery and certain weapon offenses both make the ineligible list again. This is much like Pennsylvania's. Additionally, domestic violence is excluded. Pennsylvania uses family violence as their language, a fairly common addition to the list of non-eligible offenses. And finally, let's talk about what just so happens to be my birth state, the state of Michigan, who also passed a clean slate law in 2020. Implementation will take 2 years, looking for 2022 as an implementation date. However, if the governor determines that the process cannot be implemented by the date required because of technical limitations, the governor may issue a directive delaying the implementation for another additional 180 days. This type of policy is nice in these enactments, as it's fairly useful valve for implementation dates, since a lot of automatic or automated systems are enacted without knowing all the potential technical difficulties that might arise. As many of the speakers today talked about, a lot of different agencies are keeping these records in different ways. And so making all of those systems work together can sometimes raise issues for software and much smarter people than me who are writing that software. With that said, in Michigan, misdemeanors are automatically set aside following 7 years, while felonies are set aside following 10 years. Again, that 10 years. Misdemeanors are further broken down into offenses with sentences more than or less than 92 days. Don't ask me why this number in particular, but I'm sure it does have some significance in Michigan that I'm just not aware of. The higher level misdemeanors have additional requirements placed on them, much like felony convictions. An example of these additional requirements would be a limit on the number of convictions which could be set aside for a single individual. There are also additional eligibility requirements, such as not being convicted of any other criminal offense. As you can see, Michigan's approach was to have broad eligibility definitions with exceptions and nuances for different offense classes within the category of eligible convictions. One interesting inclusion on the non-eligible list is any violation relating to human trafficking. So I just pointed this out because as many states also have special record clearing provisions for victims of human trafficking. So these are designed typically for those individuals convicted under human trafficking laws or related laws, but their conviction is from their actions as a victim of the human trafficking. Typically, these are charges of prostitution or solicitation. With that said, I don't believe Maine has one of these provisions. However, in this instance, Michigan does. It is a petition-based record clearing, which allows set aside for prostitution or related offenses if the offense was committed as a direct result of his or her being a victim of human trafficking. And so with that, I do want to say a big thank you for allowing me to speak. Before I end, I did want to briefly address a quick question or two I received but wasn't able to fit nicely in my slideshow. So first, with regard to conduct that is no longer a crime, many states have provisions requiring record clearing for decriminalized or legalized behavior. I typically go into more detail regarding this in my cannabis-specific record clearing presentation, but just know that several states have such a provision in statute. However, I don't believe Maine does. Finally, with regard to employers and ban the box policies, I do not have time to discuss in full, but NCSL does have a ban the box policy snapshot, which can also be found in our reentry and record clearing homepage. Link on the slide now. Ban the box laws limit the questions which employers can ask applicants for a position. Often this is limited to what takes place prior to an offer of employment being made. Ever since Hawaii's 1998 enactment, 26 other states and Washington, D.C. have enacted ban the box policies, but each state's policy is truly unique. And I really mean it when I say it. Only 12 states and D.C. apply laws to private employers, while the remainder focus primarily on public employers. Without getting too much into the studies, there is also a lot of debate around the effectiveness of ban the box policies. I do recommend, if you are interested in employment and ban the box specifically, to look at NCSL's policy snapshot on ban the box. There are links to all of those studies and a lot of the recent enactments revolving that as well. So with that, I will answer any questions. I know I sped through that really quickly.
Thank you, Mr. Hartman. I appreciate your speed and your overview. And are you going to make your slides available to the committee through our analyst?
Of course, I can make my slides available. I can send them off to Peggy potentially and have them forwarded over to everybody.
Thank you very much. So I am seeing I do have a few people that have questions. So the first person I saw was Barbara Taylor.
Thank you. And thank you for your presentation. Can you very quickly, or I can just email you for more information, tell me about what states have done to ensure that the subject of these records has access to their records after all these things are done to it. I'm particularly concerned about people who may have to do immigration applications. They will always be required, and the burden will be on them to provide all their records regardless of expungements or set-asides or anything else.
Well, that's actually a very good question that I don't know how to answer perfectly for you, because it seems like a very nuanced situation in which that could occur. And I don't know if a lot of states have considered it perhaps as thoughtfully as you have just now. Because in states where they do use destruction language or vacatur language, a lot of times that does mean removing all public record. So at that point, I would imagine that someone attempting to fill out that immigration work or reveal that information should my recommendation would be as truthful as possible with those individuals. However, I don't know if the federal agencies even would be able to find a record that no longer exists if it is truly destroyed. So they really wouldn't be able to challenge you on what you put in there, I guess is what I'm thinking on that one. That's a really tough question.
Okay, we'll talk.
Yeah.
Thank you.
Thank you. Laura Eustat.
Hi, thank you, Mr. Hartman, for your presentation. I work with the Attorney General's office in Maine, and I just like to, I appreciate that this is a really broad overview of what the states are doing, and the vocabulary is necessarily very general. But just so everyone's aware, you referred to pardons as not clearing something from the public record. It's exactly the opposite in Maine.
Right.
A full and free pardon does, in fact, clear the public record.
So I
just don't want people to take away from that's how it happens in Maine. And in addition, we do use the term sealing, but that's usually something that a court does in Maine. So that's pursuant to a court order. The type of automatic rendering of something confidential that you described does in fact happen in Maine, because under our Criminal History Record Information Act, the types of dispositions that you referred to, for example, in Pennsylvania as non-convictions being eligible for automatic sealing, well, all those dispositions, acquittals, outright dismissals, mistrials with prejudice, those are all confidential in Maine. So even though the NCSL chart says no automatic clearing of records in Maine,
how we looked at this is essentially looking at it from conviction records versus non-conviction records. I did mention in Pennsylvania that non-conviction records are eligible under their clean slate bill, because it is just how their system operates, so to speak. But like you're saying, in your system, those non-conviction records would preemptively be confidential. Really all of the ones you enumerated there, including the pardon one, and kind of how I guess I look at it as different, as a part of not being part of the record clearing, is that it's actually the statute that says if you are pardoned, then record clearing, or well, not record clearing, but confidentiality applies in your instance. So I guess in a way, it is the pardon that's functionally doing that, but in a way, it's also the statute that's acting to functionally do that. So, like I said, I am not the expert on pardoning. I would recommend, though, the Collateral Consequences Resource Center does have some good resources on pardoning across the states. If you are interested in that subject matter, I can also provide links to that too. Just reach out and I send you sources.
Thank you. Further questions from committee members? I'm not seeing any. So just aware of the time, it is 4:05. Luckily, our last speaker will be with us at the next meeting because it's our own Peggy Wrench. So I think we'll move that to the agenda for our next meeting, which is November 22nd at 1 o'clock. Again, it will be a hybrid, both here and on Zoom. And with that, any other questions or concerns by committee members? Peggy, what did you like to?
I know you're going to be talking about a lot of things next week, next meeting. And in your packet and posted is a comparison of what was our ceiling law. We were kind of calling it a pilot because it was repealed by its own terms. And it's comparing it with LD 1459. And that might be something you want to spend a little bit of time on between now and the next meeting so we can really talk about it in detail, because I think this might be, you know, kind of an intermediate step for you in the midst of all your other discussions and recommendations.
All right, thank you for pointing that out, Peggy, and preparing that. And Laura, was your hand up from before, or did you have something new?
That's from before, I'm sorry.
All right, thank you. No, just checking in, making sure before we head out. Anything else from any other committee members? Otherwise, I am aware of the time and would like to let you go home. I think that's it. All right, thank you all. A lot of information, a lot of great questions, and we'll see you again November 22nd.